Mr. Poe, Mr. Chairman, to some extent, this amendment is duplicitous of existing law, and I think in at least one respect it is defective. Certainly sentencing reports, which are authorized usually by probation departments, which is generally an arm of the court, has a reliability that is has a different weight than police reports, which are simply one piece of evidence. And in this case, an example, you might have a police report that, although was disproven by other evidence, which leads a jury or a judge to reach a conclusion as to a determination of guilt, to go back to a provision of evidence that was not found reliable, I don't think would be a positive addition to the immigration law. I would note also that crimes of violence are already the subject to deportation, and I'll give you an example in terms of a real-life example. When you have a domestic violence case, probably one of the most dangerous cases that a police officer can respond to, the police officers on the scene, both parties are making claims about who did what to whom, and it is not unusual that both parties will be arrested because the officer on the scene can't really sort out what happened. And so you'll have a police report that recounts the potential of activity that may, and one of the two sides is wrong, but the police report is going to include the accounts of both parties. To then say that the erroneous report can be the basis for deportation is a mistake. So I think the amendment goes a bit too far and also is redundant, although I understand that there may need to be a revisiting of this section of the law. I would suggest that Mr. Gowdy and I should sit down after this markup and see if we can't deal with the court case he has cited while focusing on the immigration law as a whole. I think that would be a productive thing for us in the body, but I think this is the wrong way to go about it. And with that, I would yield back.